I'm Tess Hardy. I'm the Director of the Centre for Employment and Labour Relations Law. Before I pass over to Rachel and Jodi, I want to acknowledge that this seminar is being held on the unceded lands of the Wurundjeri Wurrung people, and I feel like it's especially important in this week, in the lead up to the Voice referendum, to acknowledge and pay my respects to the elders, but also to acknowledge the importance of Indigenous knowledge in this institution and in society more generally. And for those who may be undecided, I really do encourage you to take a look at some of the resources that are available through the Melbourne Law School website, which features many constitutional law experts. It's called Conversations on the Voice, and if you've got friends and family who are also undecided, again, I encourage you to send that information to them. Because if you don't know, please find out. Okay, so I am so pleased to have Professor Rachel Cox with us this week. She's visiting from the University of Quebec in Montreal, an expert in this field, and I'm very delighted that she's agreed to present this seminar on addressing sexual harassment through work health and safety frameworks. And we'll also be hearing from Jodi Peskett, who is runs a consultancy project with Pia Saveri, who's also in the audience. And again, through her past roles and her current consultancy, has a wealth of experience and lots of knowledge in this area. So I'm going to pass over to Rachel. Rachel's going to speak for about half an hour, and then Jodi's going to provide some brief reflections and comments. So over to you, Rachel. Thank you.
Thank you so much, Tess. Thank you, everybody, for being here. I'm thrilled to be here. I'm very interested in exchanging with you about prevention of sexual harassment and other kinds of gender-based violence. I should just say that over the past year, I've been chairing a committee for the Quebec government on reform of all law with respect to sexual harassment and sexual assault at work. So I have been asking myself very concretely, in a very pragmatic way, what are the right choices to improve the situation for victims, for survivors? And I'm also doing some work for the ILO on preventing gender-based violence within a work health and safety framework. So I know I'm very happy to be here. Australia is known to be at the avant-garde in terms of work health and safety. And I've realized, of course, being here and looking at the legal framework, that now there have been amendments to the Sex Discrimination Act with, positive duties being created as well. My presentation today is, however, on the work health and safety framework specifically. And but I look forward to your comments and observations about the interface between the two regimes, between, in fact, the legal framework as a whole. Very briefly, I'm going to try to define sexual harassment for the purposes of saying how should we best regulate it in a context of regulation more generally of gender-based violence. Also to talk about this really quite ambivalent relationship between law and the fight against sexual harassment, because of course law was instrumental in recognizing sexual harassment at work as a phenomenon. And then we had prohibition of sexual harassment, which at least in North America dates back decades. Yet, as we saw with the Me Too movement, not a whole lot of improvement on the ground, right? So what have we learned so far? It's important to set the context for then saying, how do we mobilize today a work health and safety framework in order to fight against sexual harassment at work? And what are the really many research questions and unanswered questions that are open up before us when we have this discussion? So that's the plan. Why are we talking about it? Why? In terms of terminology, in Quebec and Canada, when we say sexual harassment, we're also talking about a single serious incident. It doesn't have to be a repetition. So that covers, for example, an isolated incident of sexual assault. We're also talking not only about conduct of a sexual nature, but also sex-based or gender or hostile work environment harassment. So hostile conduct directed at a woman because she's a woman, but not necessarily a sexualized behavior. And you also have to look, this concept of sexual harassment is ever expanding. For example, in the Ontario Health and Safety Act, sexual harassment is named and is now defined as inclusive of harassment because of sexual orientation or gender identity or expression. On the other hand, if you look at France or Belgium, sexual harassment only means behavior that is sexualized. However, sexist actions in France are also prohibited, and sexual harassment under Belgian law can also be for a prohibited ground of discrimination, including sex. So sexist harassment is also forbidden, but just there are a multitude of definitions. And it's important when we say, well, what kind of regulatory framework do we need to have in mind the really broad range of behavior that we could be talking about when we talk about sexual harassment. So in the context of the ILO convention, and I've heard that several of you here were directly involved and know that there's a backstory. Just a note that the Convention on Violence and Harassment was adopted in 2019, but it started out as an initiative of the Gender Equality and Diversity branch of the ILO. And it was here, sorry. And it was initially supposed to be a convention on violence against women at work. And the work leading up to the convention questioned that, basically. And it was decided that, in fact, in light of the fact that in sectors where women are predominant, for example, healthcare, for example, education or domestic work, there's a disproportionate amount of violence in general. So it's not just sexual violence, but violence at work. So a decision was made to say, well, we'll go for a convention on violence and harassment at work in general, but with a gender responsive approach. And one of my jobs is to say, what is a gender responsive approach in practice? And also, I mean, I didn't mention it, but obviously men are also targeted by violence at work. So this is a broader concept that's been adopted here. In terms of sexual harassment, violence and harassment is defined to include gender-based harassment. Gender-based harassment is defined as violence and harassment directed at people because of their sex or gender, but also affecting groups of people disproportionately. So that's a very broad definition. And sexual harassment is named as a specific form of gender-based violence. And then where the plot thickens for people who are interested in the regulatory framework is the fact that the convention then goes on to say, well, violence and harassment can be defined as a single concept or separate concepts. So that is kind of where things get sticky, and that's kind of where my presentation has some questions and observations. Now, what does so this approach says we're going to talk about violence and harassment at work, but with an inclusive, integrated, and gender responsive approach. And the accompanying recommendation names 3 areas of labor and employment law, one of which is occupational safety and health law, right? So that's what I'm talking about, work health and safety law today. And the convention specifically says that within a work health and safety framework, and this is important, in consultation with workers and their representatives. So that is unions, and that's also health and safety reps, because we're talking about work health and safety, when employers should be directed to adopt a policy on gender-based violence, or violence in general, but including gender-based violence and harassment, that these risks should be managed within a systematic risk management framework that is associated with work health and safety, and that there should be identification of hazards and risk assessment, again done in cooperation with workers and their representatives, be they unions or specifically health and safety reps. So that's something to keep in mind. Then the recommendation talks even further about risk assessment and says that particular attention should be paid when we're doing this process of hazard identification and risk assessment at the hazards and risks that arise from discrimination, from abuse of power, and from gender, cultural, and social norms. And on that note, I think it's important to situate sexual harassment as a technology of sexism. So a recent nationwide study in Canada found that the highest prevalence of inappropriate sexualized behavior, including behaviors that constitute sexual harassment, were found both in the 5 most male-dominated professions and in the 5 most female-dominated professions, with the difference that in the male-dominated professions, women were harassed by colleagues and by third parties in the female-dominated professions. So in other words, sexual harassment works to exclude women from male-dominated jobs, and it works to exploit and objectify women in female-dominated jobs. So that's what we're talking about. What have we learned so far? So this rather ambivalent relationship with law. In terms of prohibition and policies, we have gradually come, both as activists and as scholars, to the conclusion that prohibition, complaints-based regimes do not work. To quote, they are doomed to fail. We are looking for bad apples, and in fact, they are bad barrels. And that's really important to say, well, policies in and of themselves don't work. Complaints-based regimes don't work. In terms of the policies, again, it's not because an employer has a policy on sexual harassment that there's actually prevention of sexual harassment going on. And in fact, what we've seen is that policies, when employers adopt them, actually end up working to protect the employer and not to protect the target. Why? Because if push comes to shove in litigation, the policy is one more reason when we can say to the targeted person, why did you complain?
The policy is designed by the employer, not by the employees. That's a major risk.
Yeah, yeah, that's coming. So policies in and of themselves don't do the trick. And training, neither by itself, conventional training approaches, you get a consultant to come in to do a session that's generic and then leaves, that doesn't work either. And disturbingly, what has also been found is that in places where there's real need for sexual harassment training, but the employers use conventional approach, for example, it's been ordered, that actually makes things worse for potential targets. Yet if you say, do a session on consent without it being contextualized, without it being specific to that workplace, then people will start going, hi, touch you, you're going to have to make a complaint now, etc. So there's actually a backlash against the people most in a situation of vulnerability. So I know it's a bit of a grim portrait, but it's nonetheless our starting point. To sum up, the 3 Ps, the prohibition, procedures, and policies are, on 94th, performative. In other words, they are facade compliance. They are to make it look like the employer is doing something when they're not necessarily, and not necessarily increasing any protection from people in situations of vulnerability to harassment or people who have been targeted. So gender scholars, equality rights people have gradually post-Me Too come to the conclusion that we need to really start talking about prevention now, making harassment controllable. Starting to stop putting the responsibility on a target's shoulders to recognize and act and do the right thing when harassment occurs, and saying instead we're going to look at institutional responsibility, we're going to look at organizational drivers for sexual harassment. And there's also been some interesting theorizing now about network silence, which really brings out the role of the entire organization in shutting down targets who try to speak about the sexual harassment. And Belinda Smith, again, the rich crop in Australia, these quality scholars, has written about the promise of the work health and safety regime for making this transition from complaints-based, individual-oriented regimes to a more collective approach. So what does a work health and safety framework have to offer? So if we're looking at it as a regime, first of all, I would like to say that it's not so much a crazy idea as a continuation of a historical trend in work health and safety to expand questions from physical health to psychological health at work, and also a change in model where we start to look at the social dimensions of work health and safety, and to say, well, we need to not only look at risks to do with chemical exposures, physical exposures, et cetera, but also to look at identity-based risk. In other words, it's not just the content of job duties or occupation that determines the risk, but the context of work that determines who is exposed, and I would argue also who is helped when they are exposed. So part of a larger paradigm shift in terms of work health and safety. And what are the potential benefits of a work health and safety regime? Immediate, proactive, positive duties for the employer or the duty holder more generally. Systematic risk management. So a system where there's a feedback loop in terms of what happens, how can we improve, etc. Importantly, there's an opportunity here for worker voice. And why? Because there's a system that's set up for workers to participate, but not to participate as individuals, to participate through structures, through health and safety reps, giving unions a role. Why? Because in the context of work health and safety, knowledge that workers have of their risk, of the ability that they have, is considered important, right? So it's joint processes. And the regulatory agency, so there's some government oversight that's going to set standards, educate, etc., and also monitor. And if employers misbehave egregiously, I'm trying to remain polite, are substantial financial penalties available. For example, and I'm sure other people can correct me, up to $2 million fines, in stark contrast to human rights regime. Officer duties as well, which means that senior officers in businesses have a duty of due diligence, right, to minimize, to know what's going on and to minimize exposure to risk, etc. So in short, now accelerate. Work health and safety approach is interesting because it really disrupts the perception that sexual harassment is a private matter. It foregrounds the organizational and environmental risks for sexual harassment. It makes the employer or the duty holder responsible for exposure to risks. And very important, I talked about the work my committee did looking into recourse. Nearly all targets have lost their jobs, right? And that's really important in the sense that in a crisis situation, for example, under the Quebec regime, if a worker exercises her right to refuse dangerous work, the inspector has to be at her workplace within 6 hours, right? So there is a kind of a 911 call that can be made if the employer is not responding adequately to a very dangerous situation for the woman, which sexual harassment can be, as you all will know, I'm sure. You have a regulator that's watching the employer's efforts to comply on an ongoing basis. There's this question of voice, structures to promote worker voice. And I would add, for the lawyers, if you look compared to other labor and employment laws, coverage is much broader in terms of who is covered. Why? Because this category of workers tends to be much broader than an employee, for example, under work standards. And last but not least, it involves men in the fight against gender-based violence. So how should we mobilize the work health and safety framework? Now that I've said this is a great thing, but a good idea. I've cataloged different approaches, respect promotion policies, psychosocial risk management approaches, general violence and harassment prevention policies, standalone policies for just sexual harassment, and I've added a fifth, which I'm nonplussed by, and that's why I want to leave some room for discussion, the Australian model, which I won't even try to characterize. So largely in the States, feminist scholars are looking into respect promotion policies in order to act against sexual harassment. And they're basically saying, look, if we talk about sexual harassment, we're going to get a lot of backlash. We want to attract a lot of people with this respect promotion idea. And so we'll be strategic. If everything gets fair in the workplace, where we'll have fixed sexual harassment while we're at it without even saying the word. That's one approach. Second approach, psychosocial risk management. This is what we've been doing in Quebec. It's also the approach, for example, in Belgium. So psychosocial risks are largely related to organizational stresses. If I put this guy up on the board, it's not an accident. It's because psychosocial risk management is takes into account management prerogatives, the fact that workers don't have the right to determine their working conditions, etc. So we're talking largely here about, if I could be succinct, the ill effects of capitalism and taking into account power disparities between workers and management. Not necessarily, I might add, gender power disparities at work. Sexual harassment is going to be covered, but within the category of workplace interactions, with a subcategory of harmful behaviors, with a subcategory of sexual harassment, right? I couldn't help but notice in the ISO guidelines for managing psychosocial risk, some mentions here and there, a few words on gender-based violence, the word sexual appears, once. On the other hand, human rights legislation is considered in the following way. The norm says workers and other interested parties have a range of needs and expectations which can include legal requirements. So I put it to you, yesterday women were an equality seeking group, and today we are just needy, in need of having our human rights respected. So I categorize that category as very timidly gender responsive. In Quebec, we also found, and this is typical of a psychosocial risk management approach, that the inspectorate really went to a process-based approach, very, very shy of intervening to, in terms of management prerogatives, determining work organization. And again, in our findings, sexual harassment was perceived as really being an unfortunate occurrence between two people. Sexual assault is even worse. The inspector would say, call the police. We're like, yes, but you're the police at work. Because these were, unfortunate, unforeseeable events, well, there was no responsibility for employers to prevent. And I sincerely believe if you locked the Quebec inspector in a room, like an escape room, and you said, could you name 3 organizational risk factors for sexual harassment, they would not get out. So another response here, violence and harassment regulation. So like C190, a promising approach, that's what we've done in terms of federal law in Canada. However, no conclusive evidence that this is actually going to serve in terms of prevention of gender-based violence. Why? So before 2021, sexual harassment was prohibited in the work standards part of the Canada Labour Code. And employers were supposed to have a policy and take every reasonable means to ensure that workers were not sexually harassed. It was ineffective, as we've seen. In 2021, we kind of swung to prevention, if I might say prevention with a vengeance, in the sense that whereas the definition of violence now includes violence and harassment of a sexual nature, if you look at the 24-page detailed regulation putting those provisions into effect, you will find only one mention of sexual harassment or sexual violence, and that is a reporting obligation at the very, very end. So really, I would say too early to tell, but we seem to have swung to a very broad prevention policy, not a lot of gender response. Coming now to a standalone policy directed specifically at sexual harassment within a work health and safety framework. If you look at environmental risk factors for sexual harassment, there are a number of factors that are specific to sexual harassment. So that would be, for example, men being dominant in terms of numbers, masculinity contest cultures. For us, that would be like the construction sector in Quebec. Hierarchical structures, again, that would be like police, armed forces, but also law, also medicine in terms of a hierarchy, and apprenticeships to enter the profession. In terms of another risk factor is tolerance for sexual harassment, low worker diversity, and gender power imbalances. On the other hand, a major determining question mark factor for sexual harassment is doing precarious work, which is also a factor for a risk factor for violence and harassment in general. A climate where violence is normalized is a factor for violence, but also by the same token for sexual harassment. And an uncivil climate or an unjust organizational climate is a risk factor for violence in general, but also presumably for sexual harassment. So some togetherness, some no. In terms of the physical work environment, isolated or remote workspaces, including cars or in individual homes, is a risk factor. Alcohol, definitely a risk factor for sexual harassment, working with a client or the public. But again, all of these factors are also listed as risk factors for violence in general. So how do they play out? What is their relative importance? We don't know yet. It's not obvious that conducting a separate risk assessment is necessary or useful. In terms of risk identification, the who and how, there might be some interesting differences. Why? Because in terms of the risk, I talked earlier about worker knowledge being valued. So in order to do a proper risk assessment for sexual harassment, good practices mean that you will ask the people who are most exposed, who are most in a situation of vulnerability. So going to get those cleaners at night who work for the, when the office doors are shut, etc. In terms of how, again, sexual harassment is still a very taboo subject. You can't expect people to list it in a health and safety meeting in the same way as you would, a wet floor, for example. So we are gathering knowledge about how to go about risk identification in terms of doing safety walks, safety mapping, confidential surveys. There's an interesting online tool now where people can use to say, okay, as long as there are 15 people who will do it, this is how they're going to identify the risk in this workplace. Focus groups, work health and safety subcommittees, and even participatory research in certain contexts. So there we have some differences for sexual harassment. In terms of training and support, again, training on consent, there's some promising initiatives, particularly when women's groups are brought in to do the training on consent in the workplace. Bystander training has been seen to be, there's kind of various anecdotal or individual sectorial initiatives in terms of training bystanders because to speak up when sexual harassment is going on or about to go on. Peer-on-peer training, a very interesting initiative in the States called Sweeping Initiative by the people who sweep, the janitors, where peers go from workplace to workplace training on sexual harassment and sexual assault. Again, what we've seen in terms of support, there are specific requirements, I would argue, for people who've been targeted by gender-based violence in terms of having a trauma-informed response, being careful to listen to respect agency, etc. And by the same token, in terms of reporting, it's important for sexual harassment in particular that there be a variety of options for reporting, not just making a formal complaint. And I will zip on. And the fifth model, of course, is the Australian model, which I mentioned I'm rather perplexed about and look forward to your help understanding. So, yes, many laws, how many rights? So, in short, not a lot of literature or empirical evidence about what works in terms of risk assessment for sexual harassment. And I would add that because we're talking here about a deep structural issue, that there will always be limits to the law, and in my case today, limits to work health and safety law. However, I believe that it's a piece of the puzzle and a piece of the puzzle that's been missing. So future research questions, again, it's cocktail hour, cue the music, private house, together alone. To prevent sexual harassment, is it necessary or preferable to name sexual harassment as such? If we combine it with a risk management framework, should it be with psychosocial risk? Should it be with violence and harassment in general? Or even should it be in its own policy standalone policy. And in terms of having a standalone regime for sexual harassment, our knowledge in terms of intersectional approaches has been growing, and it raises the question, for me anyway, how do we take into account the intersection of sexual harassment with other identity-based harassment? And I'm thinking, in particular of racist harassment, because the studies will show that women will say, oh, I'm being harassed on the basis of race, whereas I might say, oh no, that was sexual harassment. How do we deal with those kinds of situations? And if we're slicing by sex, well, eventually aren't we going to have a anti-Black racism law? And then how are we going to accumulate all these different laws if we're slicing by prohibited ground of discrimination? There's an issue too in terms of capacity, because work health and safety systems have traditionally been dominated by men and men's issues, though obviously that is changing. Fast enough, question mark. There are questions about how to combine avenues of recourse, because it's important for people who suffered harm because of sexual harassment to obtain repair and redress. How do we articulate those regimes with prevention regimes? In Canada, as I said, we went to prevention with a vengeance, now very hard to get an individual remedy. And finally, I would end with the fact that prevention of sexual harassment and other forms of gender-based violence actually really represents an opportunity, in my mind, for renewal of work health and safety. Why? Because, for example, I would say in Quebec, in terms of domestic violence, what we've seen is bringing a lot of women's shelters and women's groups to cooperate with the regulator, to cooperate with employers, and with very positive results. Unifor, Canadian Union, has women's reps, and in the States now they also have Black justice reps. So the question then becomes, well, isn't this a new way in terms of fighting against gender-based violence and sexual harassment? Isn't this a new way of providing inclusion at work, including more social cohesion and equity, equality, and work health and safety for everyone? So I will end on that note. Thank you very much for your attention. I look forward to our exchanges.
Thanks, Rachel. That was excellent. That was a lot in a short amount of time. So I've been frantically writing to try and pull out some bits and pieces and connect it to what's been going on in Australia. And there's a lot that has been going on in Australia. I think one of the key things that kept coming out of what you were speaking about is, yes, law is a piece of the puzzle, like you said, but now we have these positive duties. What do we do with them? How do we make them work? And there's a few elements to that question, which is, how do the regulators who have responsibility for enforcing, ideally, these positive duties or regulating, what do they do, particularly in terms of overlapping jurisdiction? And that's a big thing that's happening in Australia, well, Victoria specifically at the moment, which I can talk about in a little bit more detail, because we have probably the most overlapping jurisdictions. So that's one piece of the puzzle. And then the other piece, I think, is how the other piece of the regulator element is, you can have a piece of legislation, you can have a regulator, but unless the regulator is equipped and has the organizational will and the funding and the resourcing to do that and the skills and knowledge, then how do you enact or enforce a piece of legislation? You can write the legislation as beautifully as you like, but it's, it's not useful to a worker who's getting sexually harassed unless they try and beat the perpetrator with the legislation, but that's not advised. So that's another question. And I think the framework we have to think about, or the way that I approach that is, I think to myself, and I think different people and with different perspectives have a different position on this. And I come from specifically a union perspective, so I have a collectivist approach. And the question I think we need to ask ourselves is, how do we think change happens, or where do we think change comes from? And how does legislation fit within that? So the regulator is a piece of that, but then there's this missing piece, which I think you highlighted a lot throughout all of your observations in your presentation. So to speak a little bit about that in the Victorian context, we have, I'll come back to the new positive duty in our equal opportunity legislation that's happened recently, but we also have we don't have so our occupational safety legislation isn't harmonized federally, so different states have different ones in Victoria, but they all have a positive duty on the employer to prevent. In Victoria, we also have that applies to work-related gender violence and sexual harassment. It's just in Victoria, so that sits there. And then we have the positive duty in Victoria, also under the Victoria Equal Opportunity Human Rights Act, so there's a positive duty around sexual harassment there, which other states don't have. So we have 2 equal opportunity pieces of legislation to consider. And then the other complicating element we have in Victoria is our new Gender Equality Act, which doesn't have a positive duty, but it definitely dabbles with sexual harassment. You know, sexual harassment is a big feature of that, and specifically around preventing sexual harassment. Even though there's not a positive duty, it's got an emphasis on prevention. So all these overlapping jurisdictions, and what we're grappling with at the moment, and I think different agencies are struggling with, is and then also you have police, obviously we have criminal as well. So the agencies are grappling with where they want a nice neat line of where our remit stops and where yours starts. And of course, with work-related gender violence and sexual harassment, it doesn't start with it's not just criminal or only criminal. It's not just and we also have fair work. That's another one I'm forgetting. So we have another one. We've got legislation up advisory here, but we have another one which is under the Fair Work Act in Australia, which is our industrial legislation. We have stop sexual harassment orders, which are similar to our stop bullying orders, which is a very individualist process. So we've got that as well. So we've got all these jurisdictions, and I think the key message or the key thing that I think I want regulators to understand, I think there's a journey there, is that you can all exist in the same space at the same time, and that's not a problem. And that if in an individual perspective, someone might pursue something, an individual remedy that might exclude them from something else. But when we're looking at that structural, holistic, as an agency enforcing legislation, we can all do our bit together. We do it, and I think the messaging here is that we do it with other issues. So, for example, if we take the issue of, we had a few years ago a big chemical fire at a factory in our western suburbs, I think. Anyone from the west? Yes, everyone's nodding. And so our OHS regulator went out because there's an OHS element there, but then so did our Environmental Protection Agency, so did the police. They all managed to work really well together, and no one kind of left once someone else got there and said, oh, it's your bit, not my bit. They all recognized the bit that belonged to them and did it. And I think we can do that with sexual harassment. I don't think we're doing it now, but I think that's a maturity issue, which you spoke to around agencies and regulators. And then the second piece of that question, I'm conscious that I'm going to run out of time, but I'll just highlight a couple other things and throw them out there because I think it's interesting for more discussion with things that you've run these. But the question is, we've got legislation, we've got regulators, but where do we think change comes from? How do we think it happens? And I think the union movement in Australia and Victoria has been a big factor in making the change happen in our space. And that change happens not from the top, but from the bottom, from a collective. So it's those things that you talked about in the OHS framework, which is that health and safety reps are empowered, health and safety committees, that unions in our Work Health Safety Act, unions have rights within that in order to do that. Same with our industrial legislation. Those are less on to be it's not as good as outcomes, but so it's about that collective change. And like you said, if you have an organisation where sexual harassment is a problem, they come and do a top-down sexual harassment training. Here's a policy that's going to make the situation worse. But if we can activate those collective structures and the powers that our legislation gives workers, that's where the change is going to come from. And I think, I'm very biased. I think work health safety is the view of that. We just need to, our agencies, our unions and our workplaces need to mature in understanding how to do that. And there's a big piece around work-related factors around risk assessments and stuff like that. I don't think we need to reinvent the wheel. It's there. It's about maturing that and activating those other levers that exist within that legislation, not just the employer and the regulator, and we're looking for compliance all the time. That doesn't work, like you've indicated. Another thing that I wanted to call out, just as discussion, so I'm not going to go on, is another element of the Victorian Equal Opportunity Human Rights Commission and our equal opportunity legislation that we have that doesn't exist in our federal piece with their new sexual harassment positive duty is this concept of representative claims. So you can take a representative claim through that equal opportunity. So if you're in a workplace and there's a whole bunch of you getting sexually harassed, or there's a whole bunch of gender bias affecting a lot of you, it doesn't require one person to make a complaint. A union could, on behalf of those workers, with those workers, take that to. So that exists in our legislation, but the commission is not funded to do it. Unions don't know about it, you know, so it doesn't happen. But there's a big opportunity there. I think also I would challenge this idea, which you've talked about, around moving towards identity-based risk in terms of assessing risk. I see the tendency to want to do that. I think we have to be cautious that we don't make individual characteristics or traits about workers the risk, so that the worker is not the risk. The risk doesn't sit in the worker. The risk is external to the worker and to that. And that applies not just for the victim survivor, but the potential perpetrator. We don't want to identify this person is the risk, like you said, because it's not just about one bad apple. We need to actually situate the risk outside of the risk in the context. So I think we agree. I just challenge the idea of identity-based. I just think it could take us down a path that would bias us eventually, if that makes sense. And the final thing is, I think it's a really interesting that you brought up around the different approaches to looking at resistance and how different countries and different jurisdictions have approached that and trying to tackle it. And some have completely avoided talking about sexual harassment and trying to kind of get it in covertly to avoid the resistance or the pushback. Others have gone in a different way, kind of facing it head on. I think a key piece of this in the maturity and how we enact positive duties and how we actually make tangible change is having a very conscious and very deliberate conversation and strategy and approach for how do we understand resistance? We need to understand resistance and backlash better. And what's our strategy for dealing with it or approaching it? And let's build that into everything we do. And that's something that elements of the actors in this space have been working on a lot in the women's sector in Victoria, but maybe at our agency level, they're not as mature. So I think that those are some interesting things that I thought about. There was a lot more to stop being up to right.
Thanks, Jodi. Yeah, thank you very much. I feel like I put them under a lot of pressure to compress a really complex and interesting area into very, very short snippets of time. So thank you very much. So I'd just like to thank our presenters again, Jodi and Rachel. Thank you very much. Thank you for all your comments and reflections. I really appreciate them as well. And thanks for your attendance. And yes, hope to see you again soon.